mainly women and their families.
Sue Moroney.
Thank you, Mr Chair. My contribution will probably last about as long as my voice for this, so hopefully that will be for a longer period of time. Can I at the outset congratulate the unions, Christine Bartlett, the Minister, but look, unusually there's another male I want to particularly congratulate with this, and it's Peter Craney, who is a lawyer who took this case. Trade unionist turned lawyer, took this case. How historic must this be for Peter to see this today being turned into a piece of legislation, and as the Minister said, an historic case that is now becoming a piece of legislation that will always be part of our country's history and will be the subject of the debate for the rest of today. So congratulations to you, Peter. You really have made a huge difference for a large number, thousands in fact, of workers and their families, and what that means for them in their day-to-day lives, and actually the go forward for their families and for generations to come just cannot be underestimated. So well done, mate. I want to talk about the commencement of the bill, the commencement clause of this bill, because hallelujah, it's the 1st of July 2017, but that's the date it's going to commence on. But gosh, it should have been an awful lot earlier. And I just want to remind people listening to this debate that actually the principles used to determine this settlement and this outcome could have happened in 1990. Could have and should have happened in the year 1990, not the year 2017 that's in the commencement clause. Because it was in that year that the then Labor government passed the Pay Equity Act 1990. And that government didn't know that it was in the dying throes of being government when it passed that legislation. But that legislation effectively set out the same sort of process that ended up being endorsed by the Employment Court in looking at the Equal Pay Act 1972. Turns out, strange isn't it, that probably didn't even need to have a new piece of legislation in 1990 to do that, but we did have it. And if that had been allowed to stay in place, if the incoming national government in 1991 had not, as its first act, repealed that 1990 Act, then these women and their families, the men working in this industry and sector and their families, men and women in other female-dominated occupations and industries would have had access to better wages for all these decades in between. And what that means, Mr Chair, is that we wouldn't be talking about child poverty in the large figures that we talk about it in this country today. Child poverty would have been in diminished numbers. In fact, I'd go as far as to say probably wouldn't even exist if the incoming national government in 1991 had not, as its first act of vitriol, actually extinguished the right of women to take pay equity cases under that Act in 1990. So, Mr Chair, I would really like to say, look, the commencement clause, I'm going to vote for it, of course, because it does bring in something that's been desperately needed for decades, because those families, those children have been robbed of this money, of this opportunity, of the right to have a decent income off the hard work of their parents for decades, looking after some of the most frail and vulnerable people in our society. And the amount of emotional work that involves, the amount of intelligent work and physical work that involves to look after people who are disabled or people who are just elderly and need that extra support, that work has gone undervalued for far too long. So I endorse this commencement title clause, and I wish it had come earlier.
Jan Logie.
Thank you, Mr. Chair. And it's